When you go into the criminal justice system, it's unfortunate, but there's a likelihood that you will no longer have a criminal defense attorney. But that doesn't mean your need to access the courts is going to end. If you want to pursue post-conviction litigation, you got to understand every different element of that. And there are many elements. That starts with a direct appeal. For some people, they may want to appeal their conviction. I had to appeal my conviction, but when I did appeal my conviction, it was for a specific reason. I didn't think I was going to get out of prison. I knew I was guilty. I knew that a jury had convicted me. I knew that it was very unlikely for me to prevail. And I didn't even pursue an appeal for that reason. I pursued it for other post-conviction remedy purposes. And I want you to be thinking about what will be the purpose of you filing this post-conviction litigation, because you may have pleaded guilty, in which case appeals are not important to you. But maybe the judge, maybe your defense attorney did not guide you well before sentencing, and you want to file a motion for ineffective assistance of counsel. If that's the case, you have to pursue what's called a post-conviction motion, which would be 2255, a motion, habeas corpus motion that you'd file with the same district court judge that you had previously, and you would argue that the system violated your Sixth Amendment constitutional right to counsel because your counsel didn't pay attention to you. It's a very heavy burden to lift, but it's not one that you can't do on your own. In fact, the form to complete a 2255 is very similar to a 2241, which you could see as an example. It's just really fill in the blanks, provide information about who you are, about what happened, you don't have to get fancy with case law or any of that kind of information. You've just got to tell the court what happened, because there's been plenty of Supreme Court precedents that says in post-conviction litigation, courts have to be very liberal when they're construing your motion. You do not have to write it as if you're a lawyer, because the judge is smart enough to figure out, well, what really happened? If you tell the judge, my defense attorney never told me that the government offered a deal for me to plead guilty and get 1 year and a day. Instead, he told me to take it to trial, and the government was not offering a deal, and he never presented that to me. That has been shown to be a violation of constitutional rights because the counsel was ineffective. He could have shown you that document, and had they shown you that document where you could get 1 year and a day, you probably would have taken it. That's what you would say. I would have taken it. I didn't ever get that information, so I was deprived my right to ineffective assistance of counsel. You don't need a lawyer to file that motion. You can do that on your own, but you have to know how to do it, and you may not know how to do it right now, but you could absolutely learn simply by reading the various case laws. You could read about the statutes. You could read the federal rules of civil procedure. You should learn about administrative remedies. You should learn about the PLRA, Prison Litigation Reform Act. You should learn about the First Step Act and your access to compassionate release. There's a lot that you can learn to help yourself. Just be prepared to know you may not have a defense attorney there to guide you, and we want you to learn everything you possibly can. I had to learn while going through 26 years in federal prison. It made a big difference in my life, what I learned from leaders, and that's why we publish it all at prisonprofessors.com, where you can get it for free. Hope it helps you. I'm Michael Santos. I believe in you.